To PLF Supreme Court show with a new year in 2026, joined by Banana Anastasia Bowden and Oliver Dunford to talk about the Supreme Court as we head towards the end of the term, 2025-2026 term. We are back with oral arguments this week. We also had our first Supreme Court decision. And so for today's show, we'll start there with the opinion. We'll talk a little bit about the arguments that are coming this week, one which has already happened but we haven't listened to, and we'll end with a few nuggets on the Supreme Court. But to start with, this was an opinion that was one of the very first ones we reviewed at the beginning of our Supreme Court show. It deals with a prisoner's right to seek certiorari before the Supreme Court. It is one of the less interesting cases that the Supreme Court has heard this year. In fact, it was so uninteresting that I had to ask ChatGPT to summarize what the decision was about for me. And after that summary, I'm like, still don't really understand it. But essentially, there are prisoners that can seek Supreme Court review for certain decisions. When they come out of a state court, there's certain procedures that allow them to seek certiorari, and if it's a federal prisoner, the question was whether this statute would bar them from seeking certiorari. I don't know that we need to get into the textual nuance of the different statutes, but the Supreme Court ultimately held that statute did not bar federal prisoners from seeking cert. Despite its boring nature, and being the first Supreme Court opinion, it was a very divided opinion, 5-4, with the Chief and Justice Kavanaugh joining Sotomayor and Jackson and Kagan. I guess Justice Gorsuch's brief decision is that there would not be jurisdiction here, and even if there is jurisdiction, that the statutory bar would prevent them from seeking cert here. That's my quick summary for our listeners of the first Supreme Court opinion of the term. Do you learned Supreme Court colleagues have anything further to say on those?
No. Well, I'll add one thing, that according to the majority opinion, Congress has to speak clearly if it seeks to impose exceptions to jurisdiction. And majority said this statute did not do that. As you said, Joshua, there are different rules for state and federal prisoners. And the majority read the federal statute as allowing prisoners broader means to get into the Supreme Court. And Justice Gorsuch said he understands the majority's desire to rule on this case because it was a circuit split, but he said there are other ways that this same issue can get to the court, and he thought that the means of getting into the Supreme Court were the same for federal and state prisoners, at least in this instance. That's about it.
Right. I would say it's in line with this court's for a number of years opening up jurisdiction to be more pro-jurisdiction than maybe prior courts have been. Not as pro-jurisdiction enough, if you ask me, but be that as it may, that is the result that the court came
Well, at least there's a statute here that says it, as opposed to the made-up standing doctrine.
Made-up standing doctrine, yeah. Oliver, you are a little quiet again, so if you can speak up or get a computer from this century, I would appreciate it.
Yeah.
So let's turn then to this week's oral arguments. We're out with a bang, but the big cases are tomorrow, which Anastasia will cover. But Oliver, what did the court hear today?
Court today heard a case involving Chevron and a number of lawsuits brought pursuant to Louisiana's Coastal Resources Management Act. And it's gone back and forth a few times. And the Chevron tried to remove this case a few times. And the removal statute for years said that, hold on one second. Let me see my, initially it said that federal contractors could remove cases from state court to federal court only for lawsuits in 4 acts that were performed at the behest of the federal government. Recently, it's been amended, and now it says that they are either for or relating to an act taken under federal direction. So the question here is whether whether the case was properly removed. The state says that it should have stayed in state court, and really the question here doesn't seem to turn too much on the law. It seems to be more of a factual question. And as the state says, the lawsuits involve crude production, and Chevron tries to kind of muscle in an action based on the refining as opposed to the crude production. It says that it's a vertically integrated company, and all this stuff that it had done, and this goes back to World War II, all that the work that it had done during World War II involved both crude production and refining. The state says, no, this is just crude production, and our allegations don't even mention refining. And the Chevron tried to, after it lost a previous attempt to remove, has now kind of adjusted its theory and now says, oh no, this involves refining too, and therefore the case should be removed to federal court.
Oh, you're muted.
I think you're muted, Joshua.
See, I tried to mute myself so Quiet Man could actually be heard.
Sorry.
But that backfired remarkably. This strikes me as not unrelated to that case heard earlier in the term with a private contractor that was being sued in tort for acts done abroad in Afghanistan. At least like there's this interrelationship between the federal government and private contractors, and to what extent jurisdiction lies, again, these jurisdictional issues with the court. But maybe I'm wrong on that, but at least the factual predicate from what I can make out from my muted friend's dialogue there seems to me as related to that. Yeah. Where's this case coming out of? What court? You're muted too now, Einstein.
That's just how he talks.
That's all right. But go ahead.
It's either the 5th or the 11th.
Okay.
So glad I unmuted myself for that.
Chevron, 5th makes sense, I would suppose. Aren't they based in Houston?
Yeah. In Louisiana is 5th.
Yeah. Okay, well, we'll be watching that case, but the big cases this week deal with trans athletes and whether they can compete as biological females or compete as girls or as females in female-sanctioned high school sports or maybe in college sports. Anastasia, tell us about this case, or these cases.
Yeah, just for some background, as you said, it's probably no surprise to anyone on Twitter or X that there has been a recent phenomenon of trans women competing in female sports in high school and in college. And a brief by some of the interveners in this case provides some of this context, and it talks about 2 female athletes who were running on a women's track and cross country team at Idaho State. And in 2019, they both lost by a significant margin to June Eastwood, a male athlete who identifies as female. And Eastwood had competed on the men's team the year before and recorded times that would have broken national women's records. So based on this phenomenon of this happening more and more, and again, these briefs go through a lot of the statistics about just how many women were deprived of opportunities to participate on the team or were knocked off the podium, etc. Based on that, some states, including Idaho and West Virginia, enacted state laws that ban transgender students from competing in the same sport as they now identify with. And so the Ninth Circuit had invalidated this law, saying that it discriminates based on sex in violation of the Equal Protection Clause. and it's overbroad because it applies even to those men who don't have a physical advantage over women. So now this goes up to the Supreme Court, and the Supreme Court has to decide whether trans-based discrimination is sex-based discrimination under the Equal Protection Clause, or maybe alternatively, whether transgenderism itself is a quasi-suspect class that entitles it to higher protection under the Equal Protection Law. This is an issue that the Supreme Court has sort of skirted. You know, it skirted that question last term in the case having to do with the states that prevented gender affirming care for minors. And they said, we're not going to really, that's age discrimination. That's something different. So here we have to get to it. Is this sex-based discrimination? Is it transgender-based discrimination? And if it's transgender-based discrimination, is it entitled to a higher level of scrutiny?
Well, I have a number of questions for you. First, is there any real difference between the Idaho and West Virginia cases?
I don't think so. It's just been consolidated. Nothing meaningful that I know of. It hasn't been talked about.
And didn't the Idaho case, wasn't there some procedural vehicle there that made it difficult, or maybe I'm imagining that?
As I recall, there was a challenger. So the people challenging these laws, of course, are transgender athletes. These interveners that I were talking about are interveners on the side of the government, right, trying to defend the law. But in at least one of the cases, the challenger wanted to give it up, didn't want it to get to the Supreme Court, or who knows? I think there was some reason, but perhaps didn't want it to go to the Supreme Court, saw how it was going, and tried to review the case, or to get out of the case, but they're hearing it anyway.
At least as a statutory matter under Title IX, hasn't this issue been resolved in Bostock, that the transgender status is a sex-based classification?
Yeah, it is interesting. I mean, that was Title VI, right? So I don't know if there's some way to distinguish that. Yeah. But you can at least also say, I mean, maybe it's the same for Title IX, but you could also say, even so, maybe it's just a matter of their competing interests here in a way that there weren't in the workplace. Here you have the whole point of the Civil Rights Act, and particularly Title IX, right, was concerned with women's rights in sports, in a way that those rights are now bumping up against the transgender athletes' rights in a way that wasn't what was happening in the workplace. In the workplace, those transgender people just saw extra protection, and it didn't give anybody else a disadvantage. And here I think the context is different.
Yeah. So then, what was it recently? Maybe it was it just Justice Barrett's questioning, or was it, I thought maybe she wrote an opinion or something dealing with how she thought transgender status was not suspect. What was that? What am I thinking of?
Yeah, it was really interesting because in the case dealing with the bans on gender affirming care for minors, the court did not address whether transgenderism itself is a suspect class entitled to higher protection. And Justice Barrett, who's been under a lot of heat recently because, I mean, very unfairly to my mind, that she's been independent, sometimes ruled against Trump when the other Trump-appointed justices have not. She's been under all this fire, and yet here she writes a separate opinion. I mean, she didn't have to, but she steps out on her own and writes this concurrence and says, hey, if we address that question, I don't think that transgenderism is a quasi-suspect class. For many reasons. One, it's, rather than being a small identifiable group with like an immutable characteristic, this group is very often in flux, and it can incorporate a wide array of gender identities. And they haven't been subject to state-sponsored discrimination in the way that groups are when we give them extra protection under the Equal Protection Clause. So yeah, she wrote. You can kind of see. We know where she's going with this, right?
I think we all would probably suspect that these laws requiring sex at birth be or different way to say it. Be the prevailing standard for girls' athletics are probably going to be upheld. Any chance I'm wrong about that, or maybe conversely, any chance that this is unanimous in that way?
I don't know that it's going to be unanimous. I mean, I do think that Justice Kagan has been really interesting and an outlier amongst the Democratic appointed justices, and I could actually see her here maybe doing something reasonable. But
Well, I mean, you see, I say that only because you see like real feminist icons like Billie Jean King being very vocal against biological males in women's sports or transgender females in women's sports. And so it doesn't strike me as necessarily liberal conservative coded to say that we need strict sex-based lines in athletics.
yeah, I don't know. I mean, we can aspire to that.
Yes, we can.
Still feels very, very politically, heated and coded.
Oliver, any thoughts?
What does Justice Gorsuch do?
Yeah, given his opinion in Bostock.
Yeah.
But in Scrimeti, he came out. He was on the majority in Scrimeti, right? Scrimeti
Yes.
being the gender affirming care case.
Yeah.
Yeah.
And I think he said something like statutory language is different. I don't know. I thought as time has gone by, I sort of see the wisdom of Justice Kavanaugh's Bostock opinion, I think, even though at the time and I still think his line at the end with, this is such a great day for trans individuals, and notwithstanding my opinion, they should be celebrating. I thought that was eye roll worthy, but it does feel like Gorsuch's opinion in that case, despite being, I think, textually sound and sort of like logically consistent, sort of missed the forest for the trees, and probably needs to be reconsidered a little bit.
Yeah, and one does wonder too if that initial question had come up to the court in this context rather than that context, whether it would have gone the same way, right? Which is just interesting to show how that matters.
Yeah.
One more set of arguments on Wednesday, Oliver. What are those about?
They involve tort claims against the New Jersey Transit Authority, but the claims were brought in Pennsylvania and New York, and so the question is, can people sue a state in another state? But the question here is whether the New Jersey Transit Authority actually is part of the state of New Jersey. And the Supreme Court, U.S. Supreme Court, applies apparently a three-pronged test now. One is the textual and structural evidence of the state's own intent. Two, the state's control over the entity. And third, the state's overall financial relationship with the entity. And so again, like the Chevron case, I don't think the decision here will come down to the law. It's simply a question of fact whether the New Jersey Transit Authority is, under that test, part of the
Is
state of
that
New
different
Jersey.
than a state action test? Would a state action sort of like, what is that, Atlanta Hotel, or is that the same test, or is this different?
No, this is just whether the entity you're suing is sufficiently part of the state to require that lawsuits be brought in the state itself. If it's not a part of the state, then the claims in Pennsylvania and New York can go forward. Pennsylvania said it. By the way, Pennsylvania's Supreme Court said it was an arm. I'm sorry. Yes, that the Transit Authority was an arm of New Jersey. The New York Court of Appeals, which is New York's High Court, said that it was not, and so the claims right now can go forward in New York, but not in Pennsylvania.
Do you think there's a scenario, now I'm completely beyond the QP and actually asking the question that I'm interested in. Do you think there's a difference between whether, could an entity be part of the state for this jurisdictional purpose, but not be a state actor for state action purposes, or vice versa? Could you have state action, but be allowed to sue them in another state because they don't satisfy this test?
Probably, but maybe you'd have to sue them in federal court. For the not sufficient under this test, but sufficient under the 1983, for example.
Right. So I guess that.
But then there's sovereign immunity.
Yeah.
in federal court.
Well, that's true. That's true.
Right. But the idea, I guess, would be for some reason, this case popped into my head, the chicken case with the cage-free eggs. So was it the Commerce Clause case? You couldn't have brought that case in, say, Arizona or whatever. You had to bring it in California. Is that what they're saying here, or am I?
I don't know. I don't think so.
I think it's saying it like can't be sued at all, right? Because
No, the New Jersey has waived sovereign immunity
in their own court.
for tort claims. Yes, but in state, arguably, and so.
But could you bring a dormant Commerce Clause challenge to a California law in a state other than California?
Dormant Commerce Clause case? I don't think so.
So let's say I'm injured as an Arizona egg farmer. Can I bring that case in Arizona against California officials? I don't think so.
Well, if California has waived sovereign immunity, and
Well, do it ex parte young, I'm saying.
No, I don't think so. Wouldn't you have to sue? That'd be federal court, though, right?
Be federal court.
But you can only sue state officials, right?
I would be suing a California state official in the District Court of Arizona for a violation of my civil rights.
I don't see why not. Couldn't you?
Yeah, if the facts or whatever occurred there, yeah, why not?
Seems odd to me.
I don't know. Maybe
It's all
not.
odd.
Why is that not what this case is about?
Because this is against the state, not officials.
Yeah.
It's a suit
Could they
against
get
the
around
state
it by
itself.
suing the officials in their official capacity?
I don't think you could recover then.
Oh, they're seeking damages, right? Okay,
Yeah.
that makes sense.
Yeah.
Okay. You guys are smarter than me.
I do think this is crazy. I'm just interested in sovereign immunity because I think sovereign immunity is so absurd, right? Like the idea that you can't sue a state when it violates your rights, and then it started sovereign immunity. Like at first it's in federal court, and they go, oh, actually state court too, and then now they're saying, oh, not only our own state court, but a different state's court, we want sovereign immunity. It's like, well, where can we sue?
I know. So I went down this road in a previous case earlier this term it was not the sovereign immunity case. I'm like, I got thinking about it so deeply that I started thinking like, well, why am I sovereign? I started sounding like those those crazy people that go to court and say like the sovereign citizen people. I'm like, I don't
We are the
obviously either.
sovereigns.
Yeah, exactly. Anyway, it does sort of raise your head a little bit about the government can just say that we don't want to be sued, and then you're just up a shit creek, I guess.
Now, this does have some federalism concerns, as opposed to just,
Understatement of the year.
well, I mean, just as opposed to merely sovereign immunity is my
Oh,
point.
I see. Yeah, sure. Okay, well, I think we made that case sufficiently interesting for our many listeners.
Could you hear me okay?
You started out really good, and then you kind of went down a little bit as you kept talking.
Anastasia was interrupting me.
Never.
Let's we'll be back later this week with a discussion of the arguments. Especially interested, Anastasia, in how the Title IX equal protection cases go. But with our remaining time today, let's pour out a beer for PLF's 6 cert petitions that were denied today. How sad. Now PLF does have one case that is being heard this term, Pung versus, it's the state of Michigan, or is there a different defendant? I don't know.
Isabella County.
Which deals with, it's sort of home equity theft adjacent and dealing with whether you can recover funds for when the government sells your property for much below market value. Definitely excited to see that case. But we had 4 other home equity theft cases that were all denied today without comment. I was on one case, I was on 2 cases, one dealing with standing in a federal contracting case that the court denied without comment, although it did ask for a response from the government. I guess my thought on that case is the government, when it got to the Supreme Court, disavowed the Fourth Circuit's reasoning. Said, yeah, the Fourth Circuit got it wrong, but because we're not really enforcing this 8A program in a discriminatory manner anymore, just deny the cert petition. The Supreme Court did that, but at least they should have like gotten rid of the Fourth Circuit opinion, which is just an atrocious, nonsensical standing decision. But it didn't do that, and that
Did you
bad
ask for
opinion.
that? Like a Munsingware
Pardon?
thing? Did you ask for that? Like a
We
Munsingware
did.
situation?
I mean, yes, we did, but it wasn't front and center of our petition, but it was in there. And then secondly, we had a petition asking the court to revisit McDonnell Douglas, which is the burden shifting framework that judges made up in the 70s to deal with Title VII claims. Justices Gorsuch, Thomas, and Kavanaugh have all written about it individually and how it's a made-up doctrine, the court should take a case. We didn't even get a call for response in that one, despite just last term the court asking for more petitions. So pretty disappointing all around, but it's near impossible to peer into that black box of why the Supreme Court takes cases and why it doesn't. And I know we've all been disappointed when the Supreme Court hasn't taken a case, but it's a rough day for PLF today.
Well, and
I've got
especially
two petitions pending.
yeah, but the disappointment also is that this is an issue that the court has addressed before, home equity theft, and kind of like when the court issued its rulings on the Second Amendment, and then a bunch of circuit courts kind of undermined those decisions, and the court, for whatever reason, doesn't feel compelled to say no, we really mean it, and tamp it down. This is another example of that. The local governments are finding ways around the home equity theft decision. In what was the name of that case we won that I can't remember at the moment?
Tyler?
Yeah, Tyler, and the court just doesn't, for whatever reason, isn't taking those cases right now.
Yeah. Any thoughts from you, Banana?
No, I was just going to plug my own cases because, the case that's going to be accepted are the two petitions about the rational basis test, particularly in the case involving a man who wants to install plumbing in his own home and he can't. I think that one's made for SCOTUS.
As do I. I will say that since we filed that case, I'm fortunate enough to join Anastasia in that petition. I've gotten so many inquiries from people like, this is outrageous. You should be able to do stuff on your own home. This is routine maintenance. So there's a lot of, the case resonates with people in a way that I was hoping it would, and it's certainly true. And the rational basis case, as Anastasia's petition makes more than clear, is a need of some clarification from the court. And we hope that they grant that.
Did we ask
I do
for?
think we've won. We've won in the court of public opinion, Joshua.
Certainly.
I agree.
Did we ask for Beach to be overturned? Right?
No.
Is that what's the course? FCC, right? Beach.
Kind of. I mean, we do argue that rational basis effectively, when it's applied like that, violates due process because you can't win and it makes judges attorneys for the government.
Yeah.
So we'll see if that's persuasive.
Yeah. Well, thank you guys for joining me. We are glad to be back with our show. We're going to keep on working to improve it, so please give us more of your comments. I did do an outline today, as you noticed at the beginning of the show, based on some listener comments. I'll try to do that in the future. Thank you to Anastasia for joining me on such short notice. Oliver, get your mic fixed. And we'll be back at the end of the week for more of a discussion on the Supreme Court. Thanks for joining us today.